Folks. Just letting you guys know we're going to give it a couple of minutes for people to continue to log on. We will try not to take too much of y'all's time just waiting, but I feel like watching participants on a Zoom webinar is a little bit like watching popcorn pop. You want to like get it to a point where there's enough of a wait between two people joining that you have a stable audience, and I don't think we're quite there yet. Of course, in this analogy, if I let it go too long, all of you catch on fire, which is maybe not where I intended this to go. All right, I've wasted enough of your time. Hello, everyone. Welcome to the American Immigration Council's webinar, Breaking Down the Border Bill. I'm Dara Lind. I'm a senior fellow at the American Immigration Council, and I am joined by two of my excellent and expert colleagues who are going to be talking us through the emergency supplemental that was published as a bill on Sunday night, and that is currently theoretically still scheduled to come up for a vote in the United States Senate this week. If we Before we start, I just wanted to kind of go through how we're going to run this. If you have questions, please put those questions in the Q&A box. Please do not use the chat. Please do not raise your hands. Use the Q&A box. We will be looking through that during the call and answering some questions kind of just directly. And then there will be a full Q&A session over video toward the end of the call once we've heard from both of our panelists. To start to talk about the enforcement and asylum side of the bill is my colleague Becca Wolf, who I am vamping because I realize I don't remember your current title. I wanted to call you Senior Policy Counsel, but that's wrong.
I'm the senior advocacy strategist,
Senior.
but any title works really.
All right. Um, so Becca, would you like to give us an overview of what this bill would do at the US-Mexico border and how it would change the asylum process?
Sure, thanks. And thanks everyone for joining us. I know that this is sort of a very hot topic and lots of information is floating around. I think I can speak for all of us when I say that our intention here is really to make sure that that we're sharing accurate and clear information about what is in the bill, what the bill does, what it doesn't do. And we will have follow-up, and there's going to be more resources on our website, etc., in the coming days or hours even. But we wanted to pull this together as quickly as possible to sort of bring it all to you all. So what the bill does, I'm going to cover the border elements, the asylum process elements, and then a little bit about what it does in terms of immigration detention and alternatives to detention, in that order, hopefully. And I think ideally, if people have questions as they come up, as Dara said, put them in the question box, please. Just to let folks know, also, I think we are live streaming this and recording it. We'll be leaving those items. We'll be turning off those items before the Q&A. And just so folks know sort of it will be available on recording afterwards. So what it does. I sort of wanted to delay and tell you all those technical things so that I could give myself a breath before going into this. We'll start at what it does at the border. So it creates what they call the Emergency Border Authority, the Border Emergency Authority, which is what is referred to largely as a trigger authority, meaning that when a number of encounters approaches a certain number, either as an average across a week or as a height in a particular day, it gives the government, the federal government, in some cases, the discretionary authority. In other cases, it requires them to, what they say rhetorically, what both President Biden and others have said rhetorically, is to, quote, shut the border. And what that means is that people will be summarily removed if they enter between ports of entry, or if they enter at a port of entry, but without coming through the CBP-1 appointments. And so that is there are some significant differences between that and the Title 42 authority. One is that there is an attendant consequence if someone is removed, if someone is pushed back or removed twice under that policy. The second time that it does trigger a ban, which is different than the Title 42 authority. So it's stricter than the Title 42 authority, but it is otherwise very similar in that people can demonstrate an exception through what we are calling the shout test. And you'll see, if you look at our written documents or other people's information about this, you'll see that this is described as needing to, quote, manifest fear. This comes from other parts of encounter parts of encounter policy, but essentially it is reminiscent of the Title 42 exception. I put that in quotation marks because it makes it is an exception that is very difficult to access. But essentially, people, when the power is in place, so when the border is, quote unquote, shut, someone needs to affirmatively manifest their fear in order to trigger an assessment of whether or not they should be allowed to seek protection in the United States. This is, at one point, was called a non-refoulement interview. It has had different names, but that is essentially what it provides. And again, the distinction here is that Whereas, at least theoretically, CBP right now is supposed to, they are required to ask questions to elicit whether or not someone has a fear of return, for a fear of return to persecution or torture. This quote, manifesting fear means that someone has to affirmatively do it or somehow otherwise demonstrate fear, which is sort of an absurd concept. And so that is, there are a couple of other exceptions, but essentially that is what the emergency authority does. And it is incredibly complicated how it gets triggered and not triggered. It is not simply the numbers issue. The way that they are counting the numbers is complicated. So who counts as an encounter for the purposes of whether or not that numeric threshold is met is complicated. There is all sorts of ins and outs of when it's discretionary, when it's required, but the nuts and bolts of it are that it both creates a discretionary and sometimes requires the government to shut down the border. And what that means in reality, again, the bill does require that even when there is a quote shutdown, quote unquote, that the ports of entry are able and processing up to 1,400 people a day. That is the current standard. That's the current number that CBP says they can process through CBP1 every day. That's across the border. So every point of entry, port of entry on the southern border. But that is written into the bill. The other thing to note is that it is the policy itself, the authority itself is time. It is limited in time. Again, theoretically, the first theoretical limit in time is that there's a sunset provision, so that the provision of having this authority at all sunsets after 3 years. We all know, for people who have done immigration policy for a while, that sunset provisions are nice in theory, not always effective in practice, because it is always easier to renew a policy that's already on the books than it is to write a new one. And so, but it is important to indicate, you know, that that is written in the bill. The other thing that is limited numerically or sort of time is that the government is only allowed to use the authority for a certain number of days per year. And that is, it reduces year after year. So the first year it has the most number of days, and then it reduces year by year. I think that all of that, you know, is indicative of negotiation, and really understanding the intense pushback that the government has had on any kind of codification of this emergency power to summarily turn people away, which is what the power does. There are exceptions and there are, you know, some nuances, but that is what the power effectively does. So that is, in a nutshell, the sort of emergency border policy. There are a couple of other things very specific to the border. One is that it eliminates the ability of the government to parole people in from the border. It simply says you can't do it. It doesn't mean that people can't be released into the country, but it's under the other release authority that impacts those individuals' powers or eligibility for different things in the future. And so it is an important distinction. So then what happens if someone does come into the country? They have established, there's two parts to this. The first part is that they've eliminated, and this is supposed to be if this is implemented, and that's a big if that we will get into, but you know, if this bill were actually to be passed, there is a number of these elements that have time to be implemented and things like that. But essentially, once fully operational, if the bill were passed, it would also eliminate the authority for the government to release people directly into 240 proceedings. So for the non-lawyers or the non-policy folks, what that means is that it eliminates the ability of the government to say, we're not going to put someone who's entering on seeking asylum in one of the expedited processes. Right now, we have one expedited process called expedited removal, and it is discretionary whether the government can put them in that process or put them directly into removal proceedings. Right, and so that's what the current status quo is. They are saying that this bill would do two things. It would, one, eliminate the ability for the government to put people into 240 proceedings at all directly from the border, unless there are a few exceptions. Basically, if they could demonstrate after the fact that someone needed to be in 240 proceedings for a particular kind of relief. And it also creates a whole new system. And so that's what I will explain next. So essentially, in addition to keeping expedited removal as a process, which is the process that folks are most familiar with, the credible fear interview as an initial step, and then being put into full removal proceedings where you can apply for asylum, withholding of removal, or other humanitarian protection, that will still be operational. But in addition, they've created this entire new regime. There are elements of it that are already in place. If folks are familiar with what are called asylum merits interviews, which is this process that a relatively few number of people have been put in at the border, where people are essentially having their cases heard by asylum officers, but they are still technically in removal proceedings as opposed to being heard by immigration courts. That is what this process is. So people would have an initial screening, and I'm going to talk about what those screenings look like. But this is a protection determination screening, or whereby an asylum officer, they are essentially getting a fear interview. This is at a heightened level. It's at the RFI, at the reasonable fear interview standard, as opposed to credible fear. In the expedited removal pathway that still would exist, the standard is also raised. So the standard for both initial screening interviews in both pathways is raised to the reasonable fear interview standard. That the distinction for folks is that essentially it's a difference between more or less needing to prove a likelihood of 10% that you would be persecuted or tortured if returned to your home country, to needing to prove more likely than not over 50% chance. So it is a significant difference, and we have statistics about the success rates of people who are going through the credible fear process versus the reasonable fear process, and it is a lower success rate at that second standard. So this new process, you would go through an interview. There are work permits that are attached to this process. And I think, again, this is a nod to the need. This is, again, at the need, related to the need of cities saying that the difficulty of people coming and having to wait for very long periods of time for work permits. So people are eligible at sort of very specific moments in time. And they are required, the government is required to do the interview within 90 days. If they do the interview within 90 days, the initial screening interview within 90 days, that interview can result in one of three things. The first thing it can result in, interestingly, is a full grant of asylum. The second thing that it could result in is a denial of basically a negative determination. And the third thing would be a positive determination. The big change in this process is that there is no immigration judicial review of any of it. And there is also an elimination of judicial review, as in the US court system, of nearly all of this. That is a significant change, and they are creating a way for the asylum office internally to create these appellate boards that can review all of these different decisions, but it never is allowed to see sort of the light of an independent adjudicator. As a reminder, asylum officers are in the business of what is supposed to be a non-adversarial interview of people seeking asylum. They are not necessarily attorneys with immigration backgrounds. And so that is a serious cause for concern, the lack of judicial review. So the person, if they get a negative determination at that interview, again, can request review, but it's only internal to USCIS and the asylum office, the sort of asylum office writ large. And then if they are given a positive determination, they are then given what they call a determination interview. Not to be confused with the first thing, which is also an interview. This is the language is difficult, but and that interview is essentially similar to what they are doing, the asylum merits interviews that they are doing currently, where it's an assessment of eligibility for asylum, withholding of removal, and protection under the Convention Against Torture. It is still a removal proceeding. There is absolutely no doubt that throughout all of this, this is a removal proceeding. And so people who go through it at the end, if they are denied, are given an order of removal. Technically, this entire process, 90 days is the maximum for the first interview, and then an additional 90 days for the merits interview. It is supposed to happen again in a total of 180 days. There are some exceptions if they don't meet this timeline. There is funding for an increase in asylum officers, which is supposed to meet this need that I think is pretty clearly, to anyone who's been paying attention, seems like there would be no way to even begin to have this conversation if there wasn't significant funding for this, but that is also included in the bill. And so I will just quickly go over the last topic and then turn it over to Adriel. Thanks so much, everyone, for listening to me rant. It's a lot of information. So what it does with detention and alternatives to detention. So there are a couple of really important things that we want to pull out here. One is that there's a massive increase in funding for detention and detention beds. And so the increase in funding for detention beds would go from about 35,000 to over 50. And that is concerning, and also obviously a pretty significant change from even Biden's position on his proposed budget months ago. So it is an increase in investment in detention. This process, this new asylum, this new protection determination process is required to be done outside of detention. It's written in the bill that it cannot be done from detention. And so it is, but those folks would be put on alternatives to detention, enrolled in alternatives to detention programs throughout the entire process. And so there are some interesting elements, the fact that those things are in the bill. There are also some sort of nuggets in the bill around alternatives to detention that are certainly of interest for people who have followed detention carefully, as the council does. I think also there's some important parts of the funding itself. Beyond the detention funding, there is funding that is in the current in our current sort of in our current appropriations package that for the border wall, and that says that money cannot be redistributed to other funding. And I think that there is also some important elements of funding for things like emergency response, and sort of some nods to the needs of interior communities and having emergency responses. I say all of that without sort of judgment, just saying that it is in the bill, and looking at the appropriation numbers, I think is important in also acknowledging where the focus of the sort of efforts around the bill can be seen. So with that, I'm going to turn it back to Jara, who's going to lead us on.
Yes, I mean, I would ask you, and I may very well during the Q&A ask you some questions, but at present we're just going to assume that everything's been answered. So I'd like to now turn it over to Adriel, because while the the changes to border and asylum policy, especially the emergency authority, have gotten a lot of attention. This bill also makes some changes to legal immigration policy, which is, for a lot of people, a little bit more, even more relevant than what is happening at the U.S.-Mexico border. So, Adriel, why don't you walk us through that?
Great. Thanks, everyone. Thanks for having me. My name is Adriel Orozco. I'm a senior policy counsel here at the American Immigration Council. Yeah, there are a few provisions that sort of expands either protections or citizenship. Um, a lot of the inclusion of these options are bipartisan proposals that have been in Congress for a few years. And I think that's where they really were able to get and adapt a lot of the language. So for example, I would say probably the one with the largest breadth is additional protections for Afghan nationals. For the last couple of years, the Afghan Adjustment Act has been proposed. It's a bipartisan bill. What's included in this emergency supplemental funding request is narrower than those bills in a lot of ways, but it does still provide a pathway to citizenship. So this bill provides first a conditional permanent residence for individuals who entered on parole starting from around July 2021. It allows those individuals to count their parole time and then their conditional permanent residency time towards citizenship, which means that if folks are able to qualify for this, people can start applying for citizenship as soon as 2025. Some folks would have to wait 4 years after the date of enactment, depending on when they were paroled into the country. So if folks don't know, about 77,000 individuals had been paroled into the United States after the US evacuated Afghanistan. So that's right now, a lot of those individuals are either currently on parole and we're able to re-parole, or some of them are applying for asylum, and some of them have already been approved for asylum. So this wouldn't include anybody who's already has a status, but it could include those folks who are on parole, who have no other options. And just as a reminder, parole is a temporary status in the United States with no pathway to a permanent status. So this would provide a lot of security for a lot of those individuals who otherwise don't have an option. In addition, the bill also has what a lot of people call, and I would call, a modest increase to green cards in the next over a 5-year period. So the last time that there was an increase in the overall allocation of green cards was in 1990. This bill adds an additional 50,000 per year for 5 years, or a total of 250,000 new green cards. They would be split between family-based petitions, which would receive 32,000 per year, and employment-based petitions, which would receive 18,000 per year. And then, while there are folks who have been waiting and will have to wait for decades, and the visa backlogs this would provide some relief to some individuals so they can get their green cards sooner. In addition, this bill also provides some protections for what some folks are calling documented dreamers. Documented dreamers are immigrant youth who entered with their parents. Their parents had temporary non-immigrant worker visas or like management visas. And so the youth, while in the United States, were just growing up. And then when they get to the age of 21, they age out of their own dependent visas. So this has been an issue that also has had bipartisan support to try to get some semblance of security for these individuals. And so what the bill does here, it provides not a pathway to citizenship, which some proposals in Congress actually have, but if it provides age out protections. So what it'll do is it'll freeze the age for certain youth. So the youth had to have been and it's also only limited to youth who are dependent on H-1B visas. So unlike proposals in Congress, which also include dependents of other types of visas, this proposal is also limited in that way. And so for the youth to qualify, they would have to have been a dependent on their parents' H-1B for 8 years, as well as have had entered lawfully into the United States. And all that would have been before they turned 21. And so they're able to get that age out protection where their age freezes so that while their green card applications are pending, they don't age out of protection, as well as some folks would be able to get work permits as well while on their H-4, which is their dependent visa, while their case is pending. So that's at least some protection for documented dreamers as well. And then I think lastly, there is also an interesting provision around temporary visitor visas for family members. Another interesting bipartisan proposal to allow family members who just want to come into the United States to visit their family a faster visa process just to temporarily enter. That visa has a limitation that the entry wouldn't count towards being able to become a legal permanent resident within the United States. So meaning that those people would be limited in being able to pursue legal permanent residency after they enter. But it does provide an alternative option for family members abroad to come in and be able to visit their family members. There are a few other things, but if we have time during Q&A, we can definitely talk about them.
Great. Thank you so much. We have a bunch of questions, including a bunch of questions that you guys have already committed to answer. So let's get right to it. I want to start, just because it's the top of my screen, with a question